Hello, I am Hank Chambers. I'm a law professor down at the University of Richmond.
Hello, Massachusetts. My name is Thomas Mackey. I'm in the history department at the University of Louisville in the Brandeis School of Law at U of L.
Good morning, Massachusetts. And Mr. DeRozier, it's nice to see your name down there, even though you've not put your face up. I'm Rita McCannon. I'm a lawyer from Huntsville, Alabama. And I'm so proud of all of you for the hard work that we already know that you've done preparing during this very, very difficult time in our country and in our world. And we look so forward to hearing what you have to say. Ms. Brown, thank you for being here with us today too. And you all introduce yourselves and we'll get going.
Nice to meet you. I'm Ellie Chapuis and we're all juniors at Easthampton High School.
Hi, my name is Megan Gravel.
Hi, my name's Alice Wanamaker. This is our teacher, Miss Kelly Brown, and our mentor, Hannah Wasinski.
Fantastic. So we'll jump into question 3 from Unit 3. And after I read it, then we will hear your opening. So in 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? We are ready for your opening statement.
The 19th Amendment and the Equal Rights Amendment both aim to create political and economic equality for women. The 19th Amendment relied on the theory of self-determination later explained by Robert Dahl, stating that women could pass their own political agenda once granted suffrage, which could include the removal of those laws discriminating against them. The ERA aimed to place sex discrimination under strict constitutional scrutiny instead of the intermediate level established in Craig v. Bourne, forcing the Supreme Court to strike down discriminatory legislation.
The ERA's broader construction made it controversial in the 1920s, as it would have removed protective labor legislation for women. Today, it could prompt immediate constitutional challenges to laws around maternity leave, the military draft, and the legal definition of rape. Depending on the outcomes of the current cases Altitude Express v. Zarda and Harris Funeral Home v. EEOC, a federal equal rights amendment could bring issues of sexual orientation and gender identity to strict scrutiny along with sex.
Self-determination through the 19th Amendment immediately led to the government furthering some women's interests. The Shepherd-Towner Maternity and Infancy Protection Act of 1921 was passed by Congress in anticipation of the women's bloc they expected to vote in 1924. The Bipartisan Congressional Caucus for Women's Issues has sponsored bills such as the Pregnancy Discrimination Act and Violence Against Women Act, which passed through advocacy from women. Because women's rights are up for political debate while men's are a given, women tend to act slightly more as a bloc. Therefore, the women's vote has made the difference for several presidential candidates, including Eisenhower, Clinton, and Obama.
Interestingly, some courts believe that the 19th Amendment would outlaw gender discrimination itself. Adkins v. Children's Hospital declared that the 19th Amendment had invalidated the common law practice of coverture, or men legally controlling their wives, and therefore it made a sex-based minimum wage law illegal. This case was later overturned under separate principles, but scholars like Reva Siegel still believe that because the 19th Amendment granted women political equality, it should have granted social equality too.
The 19th Amendment took place in the middle of a global movement to enfranchise women, behind countries like Australia and Afghanistan, but ahead of Great Britain. It was not the catalyst for global women's suffrage, but it did allow the U.S. National Women's Party to move on to international issues, like the Convention on Nationality, an agreement with the League of Nations that citizenship would be protected regardless of marriage or divorce. The World Women's Party, established in 1938, helped Jewish women escape the Holocaust and eventually received a permanent UN commission. Furthermore, after Balzac v. Puerto Rico declared that constitutional rights did not automatically apply to U.S. territories, U.S. suffragists helped Puerto Rican gain suffrage, Puerto Rican women gained suffrage in 1929.
Just over half the states have passed their own equal rights amendments, most of them in addition to ratifying the federal amendment. State ERAs usually resemble either the federal ERA or the Equal Protection Clause of the 14th Amendment. This creates discrepancies in rights granted across the states, particularly regarding the level of scrutiny for sex discrimination.
The Pennsylvania Supreme Court case Henderson v. Henderson established an absolutist standard banning any laws that classify based on sex apart from physical differences. Other states, like Virginia, simply use the federal intermediate standard. Additionally, state ERAs could make a federal ERA appear frivolous because critics can point to the many states functioning without these protections.
However, many states with individual ERAs have also ratified the federal one, and state ERAs do have benefits. Their protections apply to their state immediately, rather than being contingent on the federal amendment passing. They have also been used to expand LGBTQ rights, such as in Bayer v. Lewin, when the Hawaiian Supreme Court struck down a ban on same-sex marriage as unconstitutional discrimination based on sex. Additionally, they give credibility to a federal amendment by using the states as laboratories of democracy to test potential implications. Thank you, and we're ready for your questions.
Thank y'all so much. Here's a question. To the extent that the ERA gets at removing sex from government actions, can Congress pass statutes that are pro-women that still are constitutional under the ERA?
That's really going to be depending on how the Supreme Court interprets the Equal Rights Amendment. So under strict scrutiny, affirmative action programs have been allowed for different racial groups in Bakke v. Regents of California. So it would really depend on the level of scrutiny that the Equal Rights Amendment would establish. Because like we talked about in our statement, Pennsylvania has taken an absolutist approach. And in Henderson v. Henderson, they said that any state laws that classify based on sex are unconstitutional, except if they're based on actual physical differences.
Okay, so would the ERA provide strict scrutiny for sex difference, for statutes that make based on sex differences, or based on sex, I should say?
It definitely would at least provide strict scrutiny, but it could go even farther.
Okay. So does the ERA make it harder for us to pass pro-women legislation than we have right now? Right, because right now we have intermediate scrutiny. So if we had higher scrutiny under the ERA, wouldn't it make it harder for us to pass pro-women legislation?
I think that a lot of legislation that is theoretically pro-women would actually be better if it was written in a gender-neutral way. One example of that is the Violence Against Women Act, which gives help to survivors of domestic violence. And that law was written specifically for women because more women are victims of domestic violence than men, but it has led to men who are victims of domestic violence having a really difficult time receiving services. So I think in large part, getting rid of pro-women legislation would support men while still supporting women.
Yeah, but I think you're confusing here. The Violence Against Women Act is based on the Commerce Clause.
Yes.
Not on the 19th Amendment or a state, or obviously not the federal ERA. So that seems like apples and oranges to me. I'm not sure that's a good starting point there.
Well, I'm just saying that the ERA under strict scrutiny might counter the Violence Against Women Acts only affecting women. But if a similar act still under the Commerce Clause, as you said, was written impacting both men and women, that would be allowed and would be equally helpful to women while still being helpful for men.
Yeah, interesting. Let me shift a little bit and get you to think about 19th, possible ERA, but also the 14th Amendment, and in particular, the Equal Protection Clause. Because how come we even need to worry about an ERA if there's in fact, a 14th Amendment, which we have, and an Equal Protection Clause? Help me understand the relationship here, or none, of those constitutional and legal principles.
I actually don't think we need an ERA because of the intermediate level established in Craig v. Bourne is pretty high, and also everything that supporters of the ERA wanted to achieve has already been achieved under Title VII of the Civil Rights Act. And I think that what we really need is an equal protection amendment, because not many people understand the full implication of the 14th Amendment besides like legal scholars. And I think that if we had
and you guys.
Yeah, I think that if we have an equal protection amendment that is applied to the states, then it will make it harder for the states to discriminate people in cases such as police brutality.
Disagree. I think that the 14th Amendment alone isn't enough. And I think this is because the ERA could address more than just sex discrimination. So depending on the cases Altitude Express v. Zarda and Harris Funeral Home v. EEOC, which will determine if discrimination based on sexual orientation and gender identity are sex discrimination, the ERA could have way bigger effects. And the Supreme Court hasn't determined any level of heightened scrutiny for discrimination against transgender people. And they've only determined a heightened rational basis for discrimination based on sexual orientation, which is nowhere near high enough.
I agree with Ellie that heightened scrutiny is more important in terms of Altitude Express and Harris Funeral Home. And in terms of Megan's point, I would be in strong support of a congruence doctrine, such as the one that's already been established for racial discrimination, basically stating that the Equal Protection Clause was reverse incorporated through Bowling v. Sharp, and I think that it should need to be applied the same way to the federal and state governments.
Okay. Was Robert Dahl correct when he said that once women get the right to vote, essentially they can get all the legislation they need?
I don't think that he was correct, because I think that just because we have these de jure laws that are in place doesn't mean that we have the de facto equality that women need.
Well, if there are more women registered to vote in every presidential election for the past 6 or 8, why aren't we electing more women? And why do we not need more protection by an ERA amendment or the other, the 19th? I'm sorry, I lost my train of thought for a second. And I'm going to try to straighten out my question since I bungled it so badly. If we have way more people, women registered to vote, why aren't we electing more women? And why do we not need more constitutional protection?
I think that the reason why we don't have a lot of female candidates, can I finish my sentence?
You can finish.
Please,
I
please.
think the reason why we don't have a lot of female candidates is because of the institutional structures that are so entrenched into our political system. I think that a lot of them, such as like campaign finances and closed primaries, don't benefit women the way that they benefit men.
Great.
Good
Thank y'all
answer.
very much.
Good answer.
Thank y'all very much. Judge colleagues, what you got?
Want to really appreciate what you've done here. As you see, we're going to ask questions to make you stretch a little bit, and particularly the groups that we get a sense have something on the maybe a little bit better going for them. We're going to ask harder questions. So that's what we ended up doing here. So that's a good sign. But I'm really impressed with your control of the issues, control of the case law, and the sort of interaction between the culture as well as the constitutional principles and legal values, and how that mix comes together or doesn't over time and space. So I thought it was a really nice job, folks.
I agree with that, because it's a hard question and it's a tough issue when you've got a couple of amendments that are trying to get sex out of decisions, but we recognize that part of what we want to do is make sure that we actually have a country that is fair for women. So it's a tough issue. I think y'all did a nice job with it. You tossed in some gender stuff, which is very important, although could throw some sand in the gears to the extent that the public may be less ready for pure gender neutrality than sex neutrality. But I think y'all handled this in a real nice manner with a lot of citations and not just a whole bunch of guesses, but actually using evidence to support your position. So I appreciate that quite a bit.
I'm repeating myself a little bit from the beginning, but this is a very, very difficult undertaking when you're not in school and you don't have time to meet after school because there is no real schedule. We're not able to get together. We're not able to research together. We're not able to compare notes as easily, although I will contend that the technology is not hindering you as much as it is us. I really, really appreciate the effort that you all have made. I think you'll look back on this time in your lives, and I hope this is one of the bright spots. I hope this is one of the things that you take pride in, because it's just been so impressive to me. that you all have done such a great job. And Ms. Brown, I know you're proud, and Hannah, you as well.
Yeah, really nice folks, really well done.